In part 3, we look at the student-institution relationship as it is found today. We will first look at the statutory provision, of which I've already said a few things. We will look first at the way in which the status of students is defined under the two legislation. As I said earlier, since universities are creatures of law, you need to look at the University Act in order to determine what the student's position is. Both the AUKU and Act 555 define students in identical terms. The main difference in the case of the private sector is that the ministry performs most of the regulatory functions that are performed by the universities' authorities in the public university case. Generally, both legislation make the higher education institution a very restrictive place for students. The university is not a liberating experience. The university is not a place that encourages learning or encourages the development of students. One of the criticisms of the in loco parentis theory when it applied in the Americas, in the United States, was this. The criticism was that the universities were not in a parental position. They were not standing in a position of parents who are generally encouraging and helping their students to advance. Instead, he says, the universities were standing in the very opposite position, holding back the development. And I think if I were to make a summary of our university regulations and the way university students are treated, I will say this, that the institutions are restrictive places. They hold back development. They do not explore and experiment with students. They do not spend money in research into how education is to be carried out. You know, there is a classification of scholarship, which one of these days we should bring to the fore again. One of the classifications of scholarship in modern academia is this: the scholarship of teaching, the scholarship of understanding the learning process, the teaching process. You know, if this is a sweeping statement, and I apologize for that, I think our universities have missed that particular point. They have missed this important issue about the purpose of education and how education is to be implemented. So there are no provisions that deal with student rights, and there is no attempt to indicate the safety net that you would have for such a large group of students. In some instances, you're looking at 20,000 students as a community in a university. Your attention is not on the students, your attention is elsewhere. I don't wish to be too critical, but you know, there's this issue about the university becoming a bureaucracy serving many interests is the reason why the interests of students become subordinated. Now, there's only one important right, and I think it's worth telling, and I think we must acknowledge that this is an extraordinary right given under Malaysian law. Under both the AUKU and the Act 55, a student who is for any reason imprisoned or held in detention for a number of years or months or whatever is always entitled to come back to the university to continue his education. This is a very humane thing, because the education of an individual must be separated from the punishment of the individual. That the individual's infraction of breaking of a law, breaking a particular law, has got nothing to do with the way he is to be educated. So this, you know, is an extraordinary provision. I often show this to my colleagues in other parts of the world to say, do you have anything like this? And in most countries, they don't have that. Because in most countries, if you are convicted, you virtually lose your seat in the university. In fact, you know, if you're going overseas, they ask you at the entrance point before they give you a visa, have you been convicted? And if you've been convicted, your opportunity for education goes. Here, there is this possibility of returning after serving a term of imprisonment. Under both the legislation, the student is someone who is registered with a higher educational institution. Registration is the key to the status as a student. That registration process, of course, is something that is carried out by the university, where your name is put in the rolls and you become a student, and the enrollment is what makes you a student. Well, it makes you a student. And you must be registered for a course of study. And the course of study, it could be for a certificate, a diploma, a degree, or a PhD or a master's degree, but you must be registered for the course. That makes you a student. Under both acts, the institution has powers to regulate the affairs of the student, regulate the conduct of the student. And these powers that are given to the university to regulate the student's conduct is not limited to the student's position within the university. The university can also regulate the student's conduct outside the university. And it is in the same case, where I mentioned the quotation which I gave you earlier, where the student actually participated in demonstration outside. There was no legal action taken against him. There were police reports made against him, but there was no police action against him. The student comes back to the university and is told by the university's discipline authority, look, mate, we are going to charge you for a violation of the rule. And what is the rule? And this is the one rule that we need to be troubled about. The rule says a student will be guilty of a university offense if he brings the university into discredit, if his conduct brings the university into discredit, harms the reputation of the university. So it is this particular aspect of the rules over students under the two legislation, the statutory position I'm saying, that again, I said, needs a re-looking. In what way would a demonstration by a student outside the university with many other students affect the reputation of the university? In fact, as was argued in the court, the students said it probably enhanced the university. But no, he was brought and, he had to go through the disciplinary proceedings. And there was no, the courts showed no willingness to intervene in that. Again, as I said, the court in that case taking a very paternalistic view about the role of students. You're here to learn. You're here to learn what is right and wrong. And the university is entitled to impose restrictions on you. These are, in my view, outdated views, and they need to be re-looked at. They need to look at, you need to stop thinking about students as a dangerous group and thinking of them as part of the people who are going to lead you in the future. So that's the statutory position. The statutory position also does not recognize the students as a collective body. Remember, we mentioned earlier that students were constituent parts of the university, that they were involved in the university's processes. Under AUKU, all that the AUKU provision actually says that the students shall together constitute a body known as the Students' Union. So there is a recognition that the students in a university constitute a group. In this case, they are described as the Students' Union. But the Students' Union has no powers. They have no role to play in anything in the university except on trivial matters dealing with student welfare and student activities. There's no participation of the student in any of the other levels. I was looking at the legislation in Tanzania, which is a country that got independence about the same time as Malaysia. In Tanzania, the higher education law places the student at the level of the school, at the level of faculty, at the level of the Senate, at the level of the council, and at the level of the policy-making body in the Ministry of Education. So here is a country you think, Tanzania's participation level is really pathetic. It's only about 3% of the cohort group. we are 50% of the cohort group. With 50% of the cohort group, we are unable to recognize the value of higher education, which Tanzania is able to take on board into their legislation. Look at our neighboring country. Look at the Higher Education Act of 2012 in Indonesia. It's one of the most inspiring pieces of legislation. You can download an English version from the internet, from Google. Just say 2012 educational laws from Indonesia, and you will see the way in which the preamble to the legislation actually expresses some of the best desires of education, which unfortunately we have not been able to implement. Our implementation, as I said, is not even recognizing the student body and giving the student body any right. I shall come back to this point at the end of the very last slide. So at the moment, I think we need to go on. We are coming up to 4 o'clock, if I'm not mistaken. Let's see. All right, I'm going to take away some slides, but the civic rights of students. And civic rights here, I mean the constitutional rights, basically. Both acts recognize now that students have a right. Students have a right to form a society, organization, or of persons within or outside the country, including right to become a member of an association. This was not previously available. But despite the fact that they removed some of those restrictions on civic rights, the ghosts of those provisions still remain, and it haunts the rooms and the fields of the university. Students are banned from becoming a member of an organization, becoming a member of an unlawful organization, and the unlawful organization is to be decided by the university or the ministry. And as I said, the provision which I mentioned earlier, that the students are regulated both inside and outside. The university is again one of those restrictions coming back in a different form. The main criticism of the statutory handling of the student position is that it fails to regard the student in higher education as a social group that needs to be fostered as the torchbearers into the future and not restricted and controlled. Even if a measure of control is needed, it must be couched within specified rights that are accorded to them. As they now stand, statutes fall short in defining the rights of students. It does not indicate there is no proportionality to these rules. It doesn't say what rights or what restrictions, what balances are placed against the restrictions imposed. So students have to look at other means, other types of means to enforce their laws. They have to look at the law of contract. They have to look at the law of negligence. They have to look at the consumer protection legislation. And they even have to look at provisions in, say, the Personal Data Protection Act to try and assert their rights, to come back, to outflank, so to say, the various restrictions of the university. In the next part, we will look at the contractual relationship, and I will do 2 more of these headings, and then I will leave out some things. But let's look at the law of contract. I mean, law of contract is probably one of the most, one of the most civilized inventions. It goes back to the Roman times, and the base of that law of contract is that promises are worth keeping. That there is a value in keeping, in upholding promises, and the upholding of individual promises lies at the heart of the law of contract. And our Contracts Act, which is modeled on the 1890 version that existed in in England, in the English codified form, actually says a contract is made of 2 promises by 2 different persons, obviously. And it is this part of the contract that is very interesting. That is, when a student enters into an agreement with the university, when he registered as a student, he actually becomes a promisee. and the promisor at the same time. He promises to pay fees and do a number of things which the university requires of him. The university also promises, not as clearly as to what they would do, but the university also promises a number of things that it would do. So this notion of a contract is a very interesting notion. Put simply, the law of contract provides a legal basis for students to demand value. I'm entering into a contract, I'm paying you some money, I'm doing some other things. I want to know what value I can get from you. So basically, that is what it is. But because the contract is defined by the terms that are in the contract, you find that the terms normally do not provide enough to indicate what is the value that they're providing the student. The main elements of the formation of the contract, the offer and acceptance, the consideration, the mutuality that is required, all of that are satisfied and can be easily satisfied in the case of a student-university contract. Many universities in this country as well as overseas say, when you sign these documents, you're entering into a contract with the university. So you don't actually need to rely on any single document. It can be found in many documents, and the contract is there, binding and enforceable. The difficulty with the student contract is the nature of the value promised by the university. What are you giving me? Have you thought about it? What is it that you are getting from the university? I mean, I was a DVC at one of the universities. I got a group of students who were coming to do the master's program, and I asked them, what is it that you're coming for? And the answer, every time I asked that question, was one that was very discouraging. We are coming here for the qualification, just the qualification. There wasn't any higher ideal than that. Then I asked them, would you be happy that if I gave you the qualification straight away, took your money and send you back? And say, put up your hands if you agree to that. I'm ashamed to say that many of them put their hands up. So we are not sure as to why the student goes to the university and what it is that the university must do for the student in exchange for his money. One of the reasons the student gives value, as I said, through fees and time. And in cases where the university makes a promise that is quantifiable, courts have been willing to hold the institution liable. So if the university has promised, let us say, 14 weeks of lectures, and the university falls short of that, the university breaks it because there's a quantifiable factor. I know exactly what it is that I should have got. I have not got that, and therefore there is a breach. The court has no difficulty in bringing an action. Similarly, if the courses are supposed to start on a particular date, and I've been involved in a case of that kind in this country, and the course started 1 month after the published date, and this affected the student's ability to go back to work. And the student brought an action in the magistrate's court claiming a small sum in damage. And the magistrate at first instance says, yes, of course, there is a breach. Why? You're supposed to start on this date. You started 1 month later. And there wasn't anything in your agreement that said that you could that you have this freedom to alter the dates. The lawyer from the university actually stood up, this is a case we heard about 4 or 5 years ago, and said, oh, but university processes are complex and the university must have the freedom to make those changes. Court says, yeah, fine, but you should have made that clear to the student right at the beginning, not after the change. And here is the student is able to quantify his loss. So in that case, the magistrate, I think the amount that is awarded was some small sum like 5,000 ringgit. So the difficulty. There's no difficulty in saying what is quantifiable. So if the university says we will give you the textbooks, that's quantifiable. If the university says that we will give you access to bandwidth, that's also easily quantifiable. All of these things can be the subject of a remedy in the law of contract. But really, that's not what education is about. That isn't what the student is paying his money. He's not talking about the quantifiable aspect. There is this unquantifiable element in education. What is it that you're asking for in education? Can you reduce that into contractual terms? I'm a contract lawyer. I've drafted contracts. I've even drafted contracts, premarital contracts between two fathers who wanted their children to get married, the dowry being paid. I've drafted many contracts. But how would you quantify education? How do you quantify education? So in cases from all over the world, I mean, I'm talking only of the English-speaking world, where an action was brought in relation to some educational service, not the quantifiable part, but the non-quantifiable aspect of education, the courts will walk out of it. They say, oh no, we are not able to handle this, we are no experts in education. To answer this, I have to actually walk into the university classroom. I have to see what is taking place in the university classroom, and I'm in no position to do that. I can't decide what it is. So the courts also step away from that. So the courts need something more tangible. And there's another argument that the courts put forward, which I've stated in my notes, that is that they say that if you allow an action like this by a student against the university, you will open the floodgates of litigation. I don't know whether you're familiar with this. This is the floodgates theory. If you allow one action, there will be thousands of other actions. And the American courts, which actually have handled more cases of this nature than any other jurisdiction, the American courts have said, A, we need to look at the two values. The university and institution, higher education has got a special value. You can't damage that. If you allow litigation of this kind, you're going to damage your higher educational institution. We will not be responsible for that. So they have stepped away from that, and generally they have not taken action. But things are changing. And in fact, strangely enough, things are changing in this country too. Quantifying the unquantifiable. How would you quantify it? As I said, as a lawyer, I will tell you that it's very difficult for me to quantify what is a good education. How would I put that down in any contract? If you're not satisfied with the education, how would I put that down in a statement of claim addressed to the university? It's difficult. But the difficulties in enforcing the elusive term like good education may be circumvented by examining quantifiable incidents built into education. And there are huge amounts of that, heaps of it, because we are a regulated society. Because we are a regulated society, the irony is that the courts now have something to hold on to. And where is the good education? Well, I'll tell you where the good education is defined. Again, MQA, again in COPA. Actually, as I said, this is a remarkable document, which I think, unfortunately, not even the academics read it. But it is a document which will tell you, we can't tell you what is a good education, but these are the standards that you require. Your lecturers must be of a certain qualification. Your classrooms must be of a certain size. Your facilities must be of a certain type. These things are built into the course specification, course standards. Now, if an institution actually delivers education which the student feels is not up to his expectations, the student must examine this COPA, which is the code of practice, and see whether the university in which he is studying has in fact complied with those terms. So you can say that the education, the good education that you contracted for was not provided because the standards of a good education that has been prescribed by law have not been followed. So you can quantify. Now, I'm saying this because even as I speak, there is an action in our courts on this very point, where the student is claiming not that the education was not properly delivered to him, but that it was not delivered in the way in which the COPA regulations. Now the question is, of course, for the courts to decide, are these terms integrated or incorporated into the contract? And I think the answer to the first question will be yes. Of course, as a student, I am going into the institution, and in the institution's advertising paraphernalia, it keeps reminding me all our courses are accredited, we conform to MQA, this is our MQA number and everything else. So this quantifiable element in assessing what is a good education may allow for more actions against institutions that have not provided the good education. Yeah, we will now go on to the next slide, which is a duty of care. Now this is very, duty of care again is another common law remedy. The common law remedy basically says that institutions owe a duty of care to those who come to them for studies, for their education. This duty to the students, if it is not followed or if it is broken, then the student is entitled to compensation. And I'll very quickly go through this. I'll just deal with a case that was heard in the Terengganu High Court. And the facts of the case will establish many of the things that I'm trying to say to you. This was a student who had done her master's degree in the university, master's by research. She did her thesis, the exam board passed her, she went on to graduate, she went on and took employment in the university, and 2 years later she started a PhD in the same university. When she was about 2 months into the PhD degree, the university writes to her and says, "Would you please attend an investigation we are conducting on plagiarism?" When she went to the meeting, she discovered that the plagiarism alleged was plagiarism in her thesis as a master's student. And several months after that, she receives a letter from the university saying, "We are withdrawing your degree because of unacceptable plagiarism." So now this poor soul is losing her degree. She loses her employment in the university. And thirdly, she loses the scholarship from the government to do a PhD because she can't do a PhD without the master's degree. You know, if you look at this, you can't think of a worse situation than this. Inflicting a person. You are told 2 years after your degree that that is plagiarism. What is the university doing? And then you are deprived of all these rights. Anyway, it went to the court, and the court actually made first comment it said was, let's take this thing about plagiarism. And the court says, let's see whether there is plagiarism. And the court did this extraordinary thing, which, you know, I told you American courts would not do. They went in and they read the thesis. And they said, oh, yes, there's clearly plagiarism. We've got evidence from leading academics. Leading academics have told us that there is plagiarism in this. And we think that this thesis should not have passed muster. It should have been failed at the first instance. But the court makes this observation, and this is what I think is interesting from that case and about the duty of care. The court says the process of writing a thesis is an open activity, meaning that it is an activity that is open for examination by everyone. Here you have a student who is writing a thesis with a supervisor appointed. And the court's question was, what on earth are you doing as a supervisor? What were you doing? And the court says, the supervisor should have picked up this plagiarism very early in the stage of writing. Why did this person not pick this up? Why did they? And the court, you know, although this is not the basis of the decision, it's not the ratio of the decision, but it is an interesting observation, and an observation that should actually flash red lights all over the universities. It says the plagiarism was partly the cause of the supervisor. Something which I've been wanting to say for many years in my life. You know, we have taken plagiarism and run it through all kinds of muddy fields where it should not be. So the court says supervisor, and for once, and you know, it's a day for celebration. For once, there is recognition of the fact that the supervisor plays a critical role in the supervision. I told you we do pro bono work. We advise people. Young people are coming to us in this place saying, we've done this PhD thesis. We've done everything that was required. The supervisor tells us we've written the thesis. We say our research is good enough. The supervisor read every stage. I've not missed a single meeting. Here's my diary of meetings with my supervisor. And then the supervisor tells me I can submit my thesis now for examination. I submit my thesis for examination and I fail. And in many of these instances where I am, you know, where we are providing this service, the student is already committed to a contract for the scholarship. So in one case, the failure of the student's PhD meant that she and the family had to chalk out some 400,000 ringgit. Three years studying PhD, writing this thesis, 3 years under supervision, you complete it, it's submitted for examination, you fail, and not only did you fail, but you also have now to pay 300 or 400,000 ringgit. And this is not the only case. You know, there are so many of these instances, that, you know, it's getting alarming in my view, that the way in which the university abdicates responsibility over it. So anyway, the court in this particular case, making this remark that the supervisors play an important role, changes that relationship between the university student and the university in a significant way, where the university played an indifferent role to the way in which the thesis were written. The courts now say that if there is a failure, there is a partial responsibility of the university. As I said, I will publish this at some point, and I think it is something which is worthwhile putting across to students who are doing PhDs, and to look at the rules in which the university actually builds its own PhD or research regulations. Yeah, as I said, apart from the duty of care, apart from this court recognition, again, you come back to the MQA regulations, and the failure of MQA regulations can be a failure of the university to provide the duty of care that is required. Now, this duty of care, incidentally, is an interesting element in the consumer legislation. The consumer legislation now categorically states that in the provision of education, the provider must exercise reasonable care. So these things have changed it, and, you know, as I said, it came from a surprising end. It didn't come from the normal reformation of education. It's coming from other quarters. I'm going to go quickly through the rest of my slides. I think, yeah. This right to withdraw or cancel a degree, again, this is another right, and universities are entitled to withdraw the degree. But the one thing that you can look to is this: if they are going to withdraw a degree, they must give the person who owns or holds a degree a right of hearing. In other words, due process is even involved at that stage. Consumer Protection Act, really, you know, to be fair to the legislation, I really can't do justice to the Act today, and I will not attempt to do, other than what I've already said. That some of the things that have been said about the Act is that the fitness for purpose, that there must be procedural fairness, there must be substantive fairness, and in the university student arrangement makes fundamental changes. And as I said, my colleagues and I plan to hold a seminar on this topic, specifically on the way in which the Consumers Act apply to education. And All I can urge you to say at the moment is to say that before you make any decisions about any liability about your position at a university, get someone to advise you on the consumer legislation. That is the Privacy Protection Act. I'm just going to go through this as something that I put in there to make it complete. Under the Personal Data Protection Act, now students' privacy can be protected, but more than that, students can demand to see their exam papers. They can demand to see the exam papers on the argument that the exam paper is part of their personal information. But what is more interesting is that the Personal Data Protection Act also says that the student, in the case of a student, he can actually require the university to add his own comments where the university has made a comment on his educational prowess. So that's about where I wanted to go to today. And I'm not going to go into this student discipline and how discipline is to be conducted. I'm going to come back to my last slide because it is already 4:20 and 4:20. Is it? Yeah. Yes, it's already 4:20. And I think we need to bring this to a close. I think Professor Rom may want to say a few things. All I'm saying is this, that the last bullet point that I put there, last two bullet points, the higher educational institutions service a vital group within our societies. This is the group that we're talking about, higher education students. This group must be given more agency, and there must be more serious thought placed on the kind of services given to them. One proposal that I have to make here is this: the students as a body must be allowed to participate at all levels of administration, right from their faculty to the vice chancellor's position, to the board, to the Senate. In fact, as I said, the MQA requires some of this already, but not enough. So by making this proposal, all I'm suggesting is that bring back some of the whole history of how universities were formed. Bring students back into the fore, make them the center of education, as the rhetoric now states. So with that, I leave you and let this other last line. We must continue this discussion. I hope you will continue this discussion, and I hope you found this interesting. We will keep you informed of other webinars and seminars that we conduct. But one of the things that you need to take back, and I don't want to say thank you for listening to me, I want to say to you, if there is anything there that you find you need additional clarification, come back to us and we will try to help you with that. If you want references to the stuff that I've been talking about, I will provide that. I've not put them here. Number two is that I very strongly urge those of you who are students and student association people to start engaging with your group in using this as a guide. I hope it'll be a useful guide to inquire more into that relationship. With that, now I say thank you, and I hand it back to Professor Rom.
Thank you, you, Menon. Thank you, Mr. Menon. So there you have it. I think we have about 15 minutes to half an hour. Is that okay for discussion? Is that all right, Menon?
Yes, yes.
Okay. Now, before that, just to quickly summarize my take on my main takeaway from this is I felt it was a broad, overarching discussion of student rights and roles from the early days of the creation and expansion of the concept of the university to the present day. My main takeaway is that university students, certainly in Malaysia, have now been relegated to the role of contracted parties, essentially, dictated to rather than generally consulted with. Yeah, I'm applying broad strokes here. And the idea of universities as parents has been bastardized in many ways, where from the idea that as parents they provide guidance, it's now as parents they provide control. The assumption that we know best, yeah, and the students are not seen as capable of essentially providing their own ideas in certain areas, especially in areas as regards to politics, society, and so on and so forth. But Mr. Mann has argued that university is not the place where you go to be disciplined. It's where you go to broaden your mind, your knowledge. Yeah, and this contractual relationship that has now come about also implies that the students have rights because the student provides 3 to 4 years of his or her life, the value of his or her life to the university during that period of time. So the positive thing, I guess, that Mr. Mellon tries to point out here is that as contracted parties, they are provided under the Consumer Protection Act, and they have rights under that act, and they can do things under the Consumer Protection Act that perhaps they never thought of before. Yeah, the discussion on the Student Bill of Rights, the American Student Bill of Rights that are being brought up, the six elements of that that have been really recently brought up. I think there are implications there. If you say that universities are to provide services for market survival, for example, essentially consider the employment of students. That has been the kind of neoliberal sort of attitude towards universities, where universities are supposed to provide the labor for the market, as it were. And is that the be-all and end-all of university education? I think that's a question that's constantly been raised in relation to that idea that the universities are supposed to prepare students for the market. Yeah. And then there's on the other side, there's the fact that universities have increasingly become bureaucracies, yeah, and students are in that kind of context, within the context of this bastardization of the concept of parental guidance. Students are seen as potential threats, not as future leaders in some cases, yeah. There's also allegations that universities have become bureaucratic because external actors and institutions have become more and more into the picture. The politicization of university education, certainly in Malaysia, for example, over the last few decades, yeah, and new actors, new institutions, such as parts of the ministry and even MQA have been brought into the picture for noble reasons, we would assume, but have been disturbed somewhat, yeah, and then become controllers rather than genuine regulators, according to some allegations from various university academics as well. So these are institutions manned by human beings whose value and qualifications are now being questioned, certainly in the context of Malaysia. So Menon ends with the fact that he argues that higher education students must participate effectively at all levels of decision making. The question is, how do they get access to those different levels of decision making? Much of this was installed under the new proposed Education Act to replace AUKU, but unfortunately that has been shelved, at least for the time being. So I think to bring students to the fore, the idea of the whole talk, I guess, has been about that, about prioritizing students and urging students to look at the various possibilities there, and in this case, looking at the ways, the legal aspects of their rights. And I think there's a lot to discuss there, and I leave it